Welcome to another Legal Talk on eRadio with the Hahn and Hahn attorneys. Today we're joined by Nirvana Pillay from Hahn and Hahn, and we're answering a listener's question. The question was, can debt be written off if it's not acknowledged for a certain number of years? And does this mean I can get away without ever paying my creditors back? Nirvana is going to shed some light on the matter. Nirvana, welcome to Legal Talk.
Hi, thank you for having me back.
Nirvana, what act regulates the time period in which debts are to be paid before being extinguished?
Okay, so the question deals with the prescription of debts, and it's regulated by the Prescription Act 68 of 1969.
And what exactly is prescription?
So prescription refers to the rights of a person, a right that a person acquires, or the discharge of debts after a period of time has lapsed, and there are two types of prescription. So you have acquisitive prescription and extinctive prescription. But what we are dealing with here is extinctive prescription. And that is the extinction of a debt after a period of time, where the debt falls away if a certain time lapses, where the debtor not paying, or if the creditor does not claim payment. So a debtor can rely on prescription to legally refuse to pay their debt because the period of the debt would have lapsed. Once the debt has become prescribed, there's nothing that the creditor can do. A creditor must therefore just see to it that they enforce the agreement with their debtor.
Okay, and when does the prescription period run from, and also for how long does the period run for?
So the prescription period runs as soon as the debt is due in most cases. There are 4 prescription periods that are set out in Section 11 of the Prescription Act. So the first one is 30 years for mortgage bond debts, judgment debts, revenue debts, and debts due to the state regarding the mining of minerals. You have 15 years prescription period for debts that are owed to the state from an advance or loan or from the sale of a lease of land by the state to the debtor. You have 6 years prescription period where the debt arose from negotiable instruments or notarial contracts, except for those instances where the 30-year prescription period applies or the 15-year prescription period applies. And then you have your 3-year prescription period in instances where the debtor does not fall into any of the other 3 categories that I just mentioned.
Okay, and when is the prescription period interrupted, Nirvana?
So prescription is interrupted by either an acknowledgement of debt by the debtor, verbally or in writing, or if the debtor makes a payment towards the debt. So should the debt be acknowledged, the prescription period runs anew. Then you also have legal action, where the creditor takes legal action against the debtor, then prescription runs from scratch from the time the summons is served on the debtor. Prescription does not run while the legal action is pending. It then starts anew when judgment has been given against the debtor. And then that debt becomes a judgment debt, which is subject to a 30-year prescription period. So basically, if you're a bank customer or a debtor, none of the above has happened, and you receive a letter of demand from the bank or its lawyers or for payment of a debt you believe has prescribed in law, you should raise prescription.
Okay, and when is prescription suspended?
Okay, so suspension of prescription means that the completion of the prescription is suspended or delayed if an impediment as prescribed by the Act exists. In these instances, prescription is not completed before a year has lapsed after the impediment has been eliminated. And the following would be examples of impediments that can delay or suspend the prescription period. So where the creditor is a minor, insane or under curatorship, where the creditor and the debtor are married to each other, where the debtor is outside the country, where the debtor is an object of a dispute subject to arbitration, or where the debtor is a claim instituted against the deceased estate of a debtor, a company in liquidation, or an applicant in terms of the Agricultural Credit Act. So those are just some of the examples where prescription will be suspended.
Nirvana, lastly, what are your thoughts on the active avoidance of making payments of your debt?
So while it is possible to have your debts prescribed, it is in poor taste and in bad faith to enter into a contract with the intention of not fulfilling your obligations. So parties are always expected to act in good faith when they're contracting with one another, and this includes making arrangements when your financial situation changes and you're unable to meet your contractual obligations. The other option is to also see if you can return the item that you've bought, so that you can not only reduce your own financial strain, but also the loss suffered by the creditor. And finally, while you may succeed for a certain amount of time to avoid your creditor, eventually, if you are found, the prescription period will run from scratch. So, for instance, if a debtor can successfully avoid the creditor for 33 months and still be found, then, like I said prior, your prescription period runs again. Playing there is then futile.
Yeah, and then it starts all over again. Nirvana, thank you so much. That hopefully answers the question for today on Legal Talk, our listeners' question. Thank you.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.